All right, good morning. I'm going to call this morning's docket. When I say your name, please say present or here, raise your hand so I can acknowledge you for the docket. If you hear me repeating your name, it means I have not heard you and I'm writing down issue warrant. So make sure you speak up, okay? Ann Alvestad. Mario Martinez. Of course, received a note that Mr. Martinez indicated he'd be running 10 minutes late. We'll recall his case. John Pickney. I can't hear you. Don't assume I'm going to look up each time. Mitchell Ragland. Mitchell Wade Ragland. Stacy Rash. Jeremy Reeves. Michael Williams. Michael Scott Williams. For the record, cause number CR 21-142, CR 21-151. State versus William Robertson. Court has documentation that the defendant is in Senecor, so the court will recall that case. Paul Cohey. Thank you, Mr. Gimbel. Melody Dollar.
And I believe she contacted the state of Ham and she's having transportation issues and she is en route.
Thank you, Mr. Gimbel. Sean Crespin. Tiffany Rankin. Devin Scott Key. Devin Scott Key.
Got her here. She talked to us about 14 minutes ago. It's supposed to be 15 minutes out.
Okay, we'll recall his case.
Thank you.
Thank you, Mr. Fowles. Sean Kuntz.
It's going to be dismissed. I think we had,
Oh, that is this one. I believe I believe there was a delinquency at the pretrial release department. He has paid it.
paid online.
Okay.
I understand.
You'll collect those online. Okay. Cameron Luce.
Here. Wednesday, Thursday,
Hunter Tapper. Thank you, Mr. Fowles. Jamie Nail. Your name, sir? Nieto.
Yes.
ETO. Gotcha. Courtney Butler. Christopher Morgan. Mr. Morgan, I want you to report to pretrial release. I believe the only issue for you today is a delinquency on your bond supervision. States file a motion to dismiss. You get that paid up, you'll be free to go. So come on at this time and meet with pretrial release and they'll report back to me. Jose Perez. Anthony Collard. Is he outside?
Yes.
J. Byron Riddle. Claudia Cook. Chad Osterreich. Hannah Hampton. Brian Reyes. Thank you, Mr. Tiboletti. There you are. Okay, I didn't see you back there. All right, is there anyone who's in the courtroom whose name I've not called? You believe you're on the docket today? All right, counsel, do we have anyone that's ready? Mr. Schmidt? Mr. Osterreich? You'll come to that middle podium, please. All right, so Mr. Osterreich set for pretrial today.
That's correct. That's the one that's got the-
Any objection from the state? Additional pretrial
I didn't
request?
think so.
Yeah, so what- sorry, I thought it was signed.
I just didn't hear. from her.
It's okay. August 12th or 24th or 10th, you may be, I think you're coming back on 10th, so. All right, court will set Mr. Osterreich for additional pretrial on August 10th at 9 a.m. And Mr. Schmidt, I need Mr. Osterreich for just a moment. No, not to my knowledge. I'm gonna get him a copy of this TRN processing order. So, Mr. Osterreich. can you get me- Mr. Osterreich, I'm gonna have a copy of an order brought to you. And what I need you to do is go out to the Van Zandt County Justice Center out on Highway 64 West. I need you to present that order to them. They're gonna fingerprint you and let you go. You were arrested outside of the county. And so they need to process you in so that they can get a unique state tracking identification number for you. So they shouldn't change you out or do anything like that. And the order tells them to process that as quickly as they can, but due to staffing issues, it may be a little bit longer. So just be patient with them. Go in, they'll fingerprint you and they'll let you go. And so we're gonna have a copy of this order brought to you. After that, then you're free to go. I'm done with you. Okay. Mr. Stevens?
I had William Robertson. I saw this for 2 days ago.
Let me call the case so I can get it on the record for you. It's cause number CR 21-142-151, State versus William Robertson. Now go ahead, Mr. Stevens.
Anyway, I got the council 2 days ago, and they did go through.
I see on the paperwork, it says his graduation date would be July 28th.
Maybe that's true. 2 days ago, they did that.
Did they give you this form right here? I thought you were the one that submitted that. It's right there on the bottom.
No, I did not. I have another one that showed that his possible release was going to be June the 14th.
Oh.
I'm sorry, July the 14th.
Okay.
And that's why we set it to today, hoping he'd be out, but he's still there.
All
But
right,
yes, I haven't seen that one.
okay. Okay. Ms. Heisel, Mr. Woodwalk, any objection? Mr. Robertson is in Centacor. I do have documentation from Centacor saying that he plans to graduate on the 28th. Any objection to the court setting it post July 28th?
No, Your Honor.
All right. Do you know if you're coming back on the 10th or the 12th, Mr. Stevens? Or the 24th of August?
I was hearing the morning of the 24th.
All right, let's just set Mr. Robertson then for pretrial on August 24th, 9 a.m. You're welcome. Is that all you have, Mr. Stevens?
Yes, sir.
Do you have anything this afternoon?
I do, Your Honor. I have to leave this afternoon.
Okay, before you leave, will you do me a favor? Will you check in with Ms. Taberham? I see that we have a lot of people that do not have attorneys today that may be seeking court appointed. Will you just check with her before you leave?
And I'm going to be late to the jail this afternoon. I would have gone to your court first, but I got stuff out of judgment fees. I got 2 pleas out of it that been set for like a month or 6 weeks or something. So
Okay.
I'm going to get there as fast as I can.
Okay, appreciate it. Yeah, if you'll check with her before you leave. You have any other counsel that's ready? Mr. Nieto, you ready? And are you appearing for Ms. Warren? Okay. All right, this is cause number CR 2129, Jamie Nail.
Your Honor, asking for the reset date. We recently were able to get our complete subpoenas that we would be
Any objection from the state?
No, Judge, and I also just would note for the record, that Mr. Nieto informed me that Ms. Warren is no longer with their firm, and he is the counsel of record. So if we can have that notated, first file, just for everyone's convenience, but we have no objection per se. But I don't recall something, whatever.
Did Ms. Warren file a letter of representation?
I want to say yes. I
Yep.
believe I can follow you. We'll take it back to the office.
If you would do that, yes, that way we can show the designation. But same firm, just different lead counsel?
Yes.
Yes, if you would file that, that way we can update our system. All right, and are you requesting a certain amount of time for the reset? Typically, what I do is about 30 days.
Um,
Are you available on either August 10th, 12th, or 24th?
We can do the 24th.
All right, Ms. Nail, the court's going to reset you for docket call on August 24th at 9 a.m. And Mr. Nieto here, well, you'll need to fill this out, have her sign it, and then court, oh, you got it already, okay, court retains the white copy and defendant retains the yellow copy. And once she gets that yellow copy, she's free to go.
Thank you, Your Honor.
You're welcome. Mr. White, you ready on anything? Or do you need time? Claudia Cook. This is CR 2153. Ms. Cook set for pretrial.
Yes, sir. My understanding is, for standing order, so we're still operating under that, that's different. And the state is indicated that you have to be in protection. We'll move this over to docket call.
You have your calendar with you? Looking at setting either 10th, 12th, or 24th. You have a preference of those,
What would they do?
August 10th, 12th, or 24th.
Can we say?
Yes. Ms. Cook, you're set for pretrial August 24th. Once you sign the notice of setting and get the yellow copy, you're free to go. Oh, I'm sorry. Mr. White, I think I said pretrial, but I meant docket call. You were reading my mind for me. I appreciate that. I need more of that in my life. Is that all you have on this morning, Docket? You have anything this afternoon? Easy day for you. Not that easy. Yes, ma'am. CR 2346, Sean Koontz, Mr. Koontz, you're free to go. The state has tendered a motion to dismiss and court has signed that if you're here. Yeah. I don't think he's here. Yeah. Mr. Kimball, are you ready?
We have two matters today. All right. One, Mr. Cody is free.
Right.
And Ms. Power is in and out.
In Rouse, okay. Paul Covey, CR 2152. Mr. Coe set for docket call.
Yes, Your Honor, and we could work out a plea arrangement. We can set us for the next plea, available plea day.
Okay. Do you know when you're coming back in August? We could do it as early as July 27th, which is a week, a couple weeks. Or we could do it on August 10th or 12th.
August 10th works fine.
Okay. All right, Mr. Cohey, we're going to set you for plea before the court on August 10th at 9 a.m. Once you sign the notice of appearance and get the yellow copy, you're free to go. Mr. Brooks, are you ready?
I am, sir.
Yes, I was waiting till you were about to sit down and I was, no, I'm gonna call your name. Mr. Gimbel, just let me know when Miss Dollar gets here and I'll get you back up, okay? Sean Cressman, CR 2287. Mr. Cressman, I see that you've reached a plea agreement with the state and ask you to raise your right hand. I'm going to place you under oath. Mr. Cressman, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Mr. Cressman, is your name Sean Matthew Cressman? Are you a United States citizen? Do you read, write, and speak English? Ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Britton Brooks. Are you pleased with his representation of you? Are you pleased with him being your attorney? Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about the paperwork that you've reviewed today and signed that you do not understand? Mr. Brooks, do you believe Mr. Cressman to be competent today? You've explained to him his legal and constitutional rights? Mr. Cressman, you're charged by indictment with a third-degree felony offense of injury to a child, elderly, or disabled, and I believe it's a child in this case. Is that correct?
Yes, and Judge, that's actually the charge that Mr. President will be entering, plea to, not the indicted charge.
Okay. I see here by indictment, Mr. Cressman, you were charged with a second-degree felony offense of indecency with a child by sexual contact. But the proposed plea agreement and recommendation from the state is for you to plead guilty to a third-degree felony offense of injury to a child, with the plea agreement being 10 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended, you being placed on probation for 10 years, a fine of $3,500, court costs, and reimbursement fees. Is that your understanding of the plea agreement? Yours as well, Mr. Brooks?
It is, Judge. Thank you.
Mr. Cressman, the range of punishment for a third-degree felony offense is confinement in TDC for not less than 2 years or more than 10 years, and a fine not to exceed $10,000. You understand that range of punishment? All right, understanding the plea agreement and the range of punishment, Mr. Cressman, how do you plead to injury to a child third-degree felony? And Mr. Cressman, are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept the defendant's plea of guilt. Mr. Brooks, any objection to states one, the stipulation of evidence?
No objection, sir.
Stipulation of evidence is admitted as State's Exhibit 1, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, first of all, the state has not received probation department straight to Mr. Brooks. We would just ask the court to review those in a case of this contact condition with the victim and her family. If there's not, we'd ask that be added.
I don't see that I have the conditions of community supervision. You know if that's in there, Mr. Brooks? It's not in there. Okay. All right, Mr. Crespin, you've reviewed the conditions of community supervision. Is that correct?
Correct.
And you understand the state has requested that an additional condition be added that you've not reviewed for you to not have any contact with the victim in this case. And Mr. Brooks says he has no objection. So you understand that's going to be added into this, into these conditions of community supervision. Okay. That's probably where they went. But yeah, if you want to take them into them. And Ms. Heisel, the court has also received the victim impact statement. So I see here that the court, the state is in compliance with victim notification.
Yes, Your Honor, all the legal issues there is essentially statutory information in that. And so we provided that information to Mr. Brooks already. So the court's aware.
Thank you, Ms. Heisel. All right, the court's reviewed the evidence and thus find there is sufficient evidence to convict Mr. Crespin of this offense. The court will follow the recommendation of the state in the plea agreement. The court hereby convicts Sean Matthew Crespin of injury to a child, assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice, suspends that sentence, places Mr. Crespin on 10 years community supervision, assesses a fine of $3,500, orders payment of court costs of $290 and $90 in reimbursement fees. Court will order the conditions of community supervision to be amended to include a no contact condition with the alleged victim in this case. Mr. Brooks, I'm going to ask you or Ms. Heisel to complete that portion of the plea agreement, just so it reflects what the plea agreement is and the plea admonishments. Sir. All right, Mr. Crespin, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted by the deputy. After that time, I want you to report to probation department through this door over here. Thank you, Mr. Brooks. Good to see you.
Ms. Curry and I have been visiting about this case and also the next case for some time. Yesterday, she advised that she needed a little more time to look at the file before she would be prepared to do plea negotiations with us. I've checked with the prosecutors here, and that's also their understanding.
Any contested pre-trials at this time?
At this time, no.
Okay, so what I'll do is I'll set it for docket call and we'll set it 30 days out. Are you available on either the 10th, 12th, or 24th?
Check. Which one?
10th August, yes.
10th, we are in a, actually, we I can be here on that day. 10th, 12th. 10th is roughly the one. Ooh, I've got a status conference on it. Sure. The 10th, I think it'll be.
10th. All right, Mr. Luce, you're set for docket call on August 10th at 9 a.m. And Mr. Files, after he signs that notice of appearance and receives a yellow copy, I need him to report to pretrial release. He's going to have conditions of bond.
This show, we show a county court in Titus County. That's not a case I'm familiar with. And I believe we will be here if there's a problem on one side.
Okay.
In our other cases, Mr. Tapper, Dr. Tapper.
Hunter Tapper, CR 2370. All right, Mr. Tapper set for docket call today.
Mr. Tapper has a drug case pending that's been on the docket for some time. There is a sexual assault case out there some place in the atmosphere that is not ready to be exalted yet. And we want to try to discuss and resolve all the cases at one time. This has been hanging fire for some time, but the PA's office simply does not have the important law preservation.
I'm gonna take just one moment, check his file. I have a notation here that Mr. Tapper failed to report on pretrial release for May and June. And so I'm trying to see when Mr. Tapper signed his conditions of pretrial release. Do you have any information on that?
May I say that?
Yes, please.
I noticed that we have apparently some confusion. Please stay in touch with our office. Does the court have a indication being signed?
And that's what I'm reviewing. Let's see. Yes, I'm showing that Mr. Tapper signed conditions of pretrial release with Ms. Burns on March 9th of 21. So I'll tell you what we'll do, Mr. Tapper, just come over here and have a seat in the jury box. I'm going to have you drug tested today. You pass the test, we'll pass the case. If you don't pass the test, we'll have a conversation about that.
They're having to do a review on a portion of the keys judgment. We started out as a felony, we're putting in for a day and fine.
Okay, so just wait on paper.
We're back and forth, and that's done.
Yes, sir, please. Mr. Noel, you ready? Are you ready for me to call those or do you need time? Mr. Riddle, come on up. This is J. Byron Riddle, CR 2355-359. Mr. Riddle is set for a docket call on each case. Go ahead.
Then we, I indicated earlier, we met about 2.5 hours yesterday. I thought Stephanie had made the error supplying all the videos. Actually, I made the error setting off the DVD before all the videos played as opposed to just watching them right in jail. I'm thinking I have all the videos, but all the TV case, I don't actually look at the videos. We don't really need another pre-trial. So I just consider it on a regular docket call. This position, I think, is the problem. I don't know what to say.
Set on the call, we also submitted an offer yesterday, and so I think that's, this Riddle is facing significant prison. So we would have no objection to him having an extra 30 days to consider the new offer.
But they didn't relay the offer to him this morning, but obviously.
All right, this is the second docket call we've had. So the next docket call will be the final unless there's a compelling reason that we should go past it. So. All right, we will set, do you have your calendar available? Do you know when you're coming back in August? 10th, 12th, or 24th? 24th? You sure you want to check to make sure? I'd rather you be sure than file a motion for continuing. All right. Court will set Mr. Riddle then for docket call, final docket call on August 24th. And on that date, Mr. Riddle will either announce plea agreement or request for a trial. Once you get that yellow copy, Mr. Riddle, you'll be free to go. I appreciate that, sir. Being here is the important part, so I appreciate it.
Other approach.
Yes, and Mr. Knoll, have you given Mr. Riddle his notice? Okay. Are you ready on your other client, Mr. Collard? Mr. Knoll, do you want me to call that? Or are you still working on that one? Okay. Okay. I just didn't want you to forfeit your spot. And you're ready on Mr. Key? Yes.
Basically, we have a paper pledge. The judgment had been prepared for a year of probation for 2 years. Our agreement was a day in jail with credit for time served and fine. So if we can get the papers, I prefer if Ms. Curry's staff can take care of it, to go ahead and do it today, rather than come back on it.
He's going to do a day. Is he going into custody today? Is that what you said?
No, he already has the credit judge and he's going to pay it full amount off.
Okay.
It's just, and I don't have any objections. The court does. You know, and hearing it in court, signing the judgment later.
I like to do it all at the same time. That way I can make sure it's correct. And that way I don't have to re-fingerprint him. I mean, he's going to stick around and get fingerprinted on it or.
I'd rather-
It won't take long.
I'd rather stay over and get it done.
Okay.
Rather than come back.
Okay, that's fine. You ready? Hannah Hampton. Hannah Hampton, CR 2390. Hampton, if you'll come to the middle podium. Mr. Wagner, I show that Ms. Hampton's set for docket call today.
Yes, I would if I could just get a little more time.
Is the purpose of tracking people down for plea negotiations or trial?
Yeah, for trial. Yeah.
Is Ms. Okay, is Ms. Hampton rejecting the plea agreement? Is Ms. Hampton rejecting a plea agreement?
This time.
Okay, so just typically how this court handles its criminal docket is we go from arraignment to pretrial to docket call. And so today's docket call, and what I like to know is the defendant been extended a plea agreement offer? And if it is, if they have, what is it? If it's being rejected, and then if you're requesting a jury trial or a bench trial, and then I'll schedule it.
I don't think it will reject any agreement this time, but I'm still, like I said, still gathering some evidence.
State.
Yes, we have been given,
The state have a position?
Those two, reset.
Is he getting information to give to you, or is he just getting information for the defense?
for the defense.
I find that this is the first docket call, so I will reset for an additional docket call in 30 days. Are you available on August 10th, 12th, or 24th?
12th, is that a Thursday?
Yes, sir.
Right now, August 12th.
Okay. All right, Ms. Hampton, the court's going to set you for an additional docket call on August 12th at 9 a.m. Once you sign the notice of appearance and get the yellow copy, you'll be free to go.
Thank you, Your Honor.
You're welcome. I don't see anybody jumping. Anybody ready?
All right.
All right, Mr. Manning. Courtney Butler, CR 20-152. Is that a plea today? Yes, sir, please. Good morning, good morning. All right, Ms. Butler, if you'll raise your right hand. Ms. Butler, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, Ms. Butler, you can put your hand down. You are Courtney Nicole Butler, is that right?
Yes.
And Ms. Butler, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Are you currently on medication or undergoing treatment for those? And do you feel like you have a rational understanding of the proceedings here today? There's nothing about this proceeding that you're confused about? And are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes.
And there's nothing about the paperwork that you've reviewed and signed here today that you do not understand? And so the pretrial intervention contract involves waiver of some very important rights. One of those being your waiver of right to a jury trial. You understand that the jury trial is guaranteed to you by the Constitution, and that cannot be waived by anyone except you.
Yes.
And you understand that if you waive your right to a jury trial, that may not be restored to you unless there's a very specific and limited circumstance.
Yes.
And by waiving your right to a jury trial, you understand that if you enter in this program and that right's not restored to you, that you do not have the right to have a jury come in and hear your case. And you also lose the right to confront the state's witnesses and their evidence in front of that jury. So you've discussed this with your attorney, Mr. Manning, correct? And you're asking the court to allow you to waive your right to jury trial. All right, the court will find, well, let me ask you one more question, Ms. Butler. Has anyone threatened, forced, or pressured you to waive your right to a jury trial?
No.
You've done this of your own free will and accord? All right. Court finds that Ms. Butler has been admonished of her right to a jury trial, has intentionally, knowingly, and voluntarily waived that right. court does approve the waiver of jury trial. I notice it's not signed by the state, so that'll need to be signed at some point. Ms. Butler, you also understand that you would be waiving your right to a speedy trial, and you'd also be waiving your right to have certain records expunged from your criminal history if the case is later dismissed. Do you understand that? And Ms. Butler's already paid her fee to the,
We have worked out with the DA's office, we paid us time.
okay. All right, Ms. Butler, you do understand that if the court approves this contract and allows you to enter into this program, that on the charge of abandoning or endangering a child with criminal negligence, that is a state jail felony offense. And if you get into this program and you violate the terms and conditions of the contract, that you could be brought back to court and you could be subjected to a bench trial, in which part of this agreement is you're going to stipulate to the offense report and other pieces of evidence that the state's going to use against you. You understand that? And you understand that the range of punishment for a state jail felony is confinement in the state jail prison for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. That would be the range of punishment that you could be subjected to if you violate or brought back for trial and proven guilty. And understanding those things, you want to go forward and enter into this program for a period of 1 year. All right, court will approve Ms. Butler being placed on the pretrial intervention contract for a period of 1 year. We take this to Ms. Heisel. She needs to sign in all spots. All right, Ms. Butler, you come over here and have a seat with in the box, and then the probation department will give you further instructions, okay? Yes, sir. Let me censor you. Now serving number 72. You have another one?
No.
Let me write you in here. John Pickney, CR 21-184. All right, Mr. Pickney, the court has reviewed your application and request for court-appointed attorney. Court finds you to be indigent on this date and has appointed the Honorable Richard Schmidt to represent you. Mr. Schmidt, have you had an opportunity to review the indictment with Mr. Pickney? August 10th date? Does that give you enough time? If not, I mean, we can look to push out further. I'm not opposed to that. Be 14th, 14th or 16th. All right, Mr. Pickney, the court's going to set you for a pretrial hearing before the court on September 14th at 9 a.m. Yes, Mr. Pickney, the court has ordered you to conditions of bond. That means that the bond you pay posted in this case is going to have conditions that you report to the pretrial release department, that you pay towards your court-appointed attorney fee, that you remain drug-free, be drug tested, those things. So I'm going to ask you to report back over here to Mr. Waddell and the pretrial release department, and they'll give you paperwork and additional information. So you can come around this way and see Mr. Waddell.
Do you know?
Right.
I think so. Mr. Gimbel, you ready? Ms. Dollar, CR 21-111. Stoller is set for pretrial today.
Yes, Judge, and she has been in touch with me in that time, and I have been unable to visit with her for deeper discovery. I've spoken with the state, and I don't believe they have any objection. We could reset this for, give one more docket call. I think we'll likely resolve this matter.
You want a docket call or a pretrial?
Pre-trial.
All right, court will reset. Are you requesting a certain date?
Will be first on August 10th.
Okay, if you feel like that's enough time, the court will reset Ms. Dollar then for pretrial on August 10th at 9 a.m. Ms. Dollar, once you sign the notice of appearance, get the yellow copy, I want you to report to pretrial release and discuss with them your financials. You need to start reporting, and I understand you may be in custody, so there may be some delinquency. So I want you to talk with them and see what you got to do to get caught up, okay? So you can come on around and meet with them, and then you'll be free to go, okay? Is that all you have, Mr. Gimbel?
Until this afternoon.
Okay, if you'll do me a favor and check in with Ms. Taberham before you leave.
Will do.
Thank you, sir. Thank you, ma'am. Anthony Collard. Mr. Collard, if you'll raise your right hand, sir. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Make sure you speak up for me so my court reporter can hear you. And can you see him at all? Will it help if we move this over a little bit? Okay. All right, Mr. Collard, is your name Anthony Dale Collard? And Mr. Collard, are you a United States citizen? Do you read, write, and speak English? And have you ever been diagnosed with any type of mental condition? You're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him and have all your questions answered? Is there anything about the paperwork that you've reviewed, read, and signed that you do not understand? Feel like you understand everything that's happening today? Mr. Knoll, do you believe Mr. Collard to be competent today?
Do your honors.
And you've explained to him his legal and constitutional rights?
I am.
Mr. Collard, you're charged by indictment with a third-degree felony offense of prohibited weapon. A third-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement. That means any plea agreement or sentence handed down by a court or a jury must fit within that range. Do you understand? I see the plea agreement here is that you're going to plead guilty to that charge. The state's recommending your punishment be 6 years in TDC, with that being suspended and you being placed on probation for 4 years. You understand that? So if the court approves this, then that means you would be placed on conditions of community supervision. And if you violate those, the state could file a motion to revoke your community supervision, bring you back before the court. And if they prove to me that you violated, then the court could revoke and sentence you up to 6 years in prison. You understand that? Understanding that range of punishment and that plea agreement, how do you plead to that charge? Are you pleading guilty because you are guilty? Has anyone threatened, forced, or pressured you to plead guilty? All right, court will accept the defendant's plea of guilt. Mr. Knoll, any objection to states one?
No, your honor.
States one is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense?
No, your honor.
All right, courts reviewed the evidence, finds that there is enough evidence to convict the defendant. Court will follow the plea agreement in this case. Court convicts Anthony Dale Collard of possession of prohibited weapon, a third-degree felony. Court assesses his punishment pursuant to the plea agreement at 6 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence, places Mr. Collard on 4 years community supervision, orders him to pay a $2,000 fine, $290 court cost, and $785 reimbursement. All right, Mr. Collard, court orders you come forward to be fingerprinted with the deputy. After that, an order you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. So after you get fingerprinted, just step over here and Officer Insurer will give you more information.
That's all I have.
Yes, sir. You have anything this afternoon? Well, let's look before you leave then. So you don't get that awkward phone call. I don't see you on here, but I could write your name in here if you want. It's all interesting, Mr. Knoll. It's all interesting. All right, have a great day. Good to see you. Mr. Tibblett, are you ready? Brian Reyes. You have plea papers. How's it going today? Doing great. All right, Mr. Reyes, if you'll raise your right hand, I'm going to place you under oath. Mr. Reyes, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, Mr. Reyes, you can put your hand down. You are Brian V. Reyes, is that correct? And Mr. Reyes, are you a United States citizen? No? Okay, so you are a lawful permanent resident. And do you understand that a disposition in this case pursuant to this plea agreement, which would result in a conviction under section 1244B as a misdemeanor, could have an impact on your lawful residence in this country? And have you discussed those issues concerning immigration with Mr. Tibblett or any other attorney? No? Okay.
We spoke about it.
What did you say? I can't hear you, Mr. Ray. Okay, go ahead, Mr. Tibblett.
Judge, we visited about it. I told him, I explained everything to him, and he wished to proceed under this manner, not believe this man.
Okay, and do you believe him to be competent today?
I do not.
Mr. Reyes, you ever been diagnosed with any type of mental condition? And are you pleased with Mr. Tibbolett's representation of you? Feel like you understand everything that you've read and reviewed today? Don't have any other questions about your case? All right, Mr. Reyes, you are charged by indictment with a state jail felony offense of possession of controlled substance of penalty group 2 less than 1 gram. However, the plea agreement in this case calls for a plea of guilty under section 1244B of the Texas Penal Code. If the court follows the plea agreement, you would be convicted as a misdemeanor offender, a class A misdemeanor of possession of controlled substance, which carries a range of punishment of confinement in the county jail not to exceed 365 days or a fine more than $4,000. You understand that range of punishment? All right, understanding that range of punishment then, Mr. Reyes, how do you plead to possession of a controlled substance penalty group 2 less than 1 gram? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, and Mr. Tibblett, any objection to states 1?
No, no.
All right, states 1, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession, accepts the defendant's plea of guilt. Anything further from the state?
No, no.
From the defense?
No, no.
Mr. Reyes making any arrangements to pay towards the fine or court cost that he owes today? Yes. How much are you paying today? All right, we appreciate that, Mr. Reyes. Was there a weapons charge that originated out of this that's not before the court?
Not that was, the co-defendant, Your Honor, I believe may still be barred, but there was, he was a passenger in the car for that gentleman's charge.
Okay. So he doesn't have a charge of,
He does not.
okay. All right, then based on the court's review of the evidence, I do find that there's sufficient evidence to convict Mr. Reyes. Court will follow the plea agreement and recommendation of the state. Court hereby convicts Brian Reyes under section 1244B of the Texas Penal Code with a class A misdemeanor offense of possession of controlled substance and penalty group 2, less than 1 gram. Court assesses his punishment at 1 day confinement in the county jail, issues him credit for 1 day for time served in this matter. Court assesses a $2,000 fine, $180 restitution, and $270 court costs. All right, Mr. Reyes, you're hereby remanded to the custody of the Van Zandt County Sheriff's Office to carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the deputy. And then after that, you can step across the hall to the district clerk's office and make your payments, okay? And then if you're not paying everything in full today, then you'll need to go down to the other end of the hall and speak with them about setting up a payment plan so that you can pay out the rest. And if you don't pay out the rest, the court's gonna issue a warrant for your arrest, okay? All right, go ahead and step forward here. Okay. Just all of it. Okay. Yes, thank you, Mr. Blake. Appreciate it. You're welcome. We have any other counsel that's ready?
Yes, Your Honor.
Yes, and this is on Mr. Key. So Mr. Key.
Yes, Your Honor.
Devin Scott Key, CR 2292. Do you have the paperwork, Mr. Falls?
Yes, Your Honor. There's a, yes, on the felony case that was originally on the docket for today. That's the first page. The other papers goes to the misdemeanor plea.
All right, this is cause number CR 2292 and CR 21258. Mr. Key, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Go ahead, Mr. Falls.
Please state your name for the record. Keep your voice up, please, so that I can hear it, they can hear it, and was important to judge in here. Mr. Key, you originally indicted himself under CR 20-00292 for the second degree felony sexual assault. Is that correct? Yes.
Yes, sir.
And we have been representing you on that matter.
Yes, sir.
On your behalf, you're aware that you engaged in negotiations with the business attorney over here, Mr. We have reached an agreement subject to your approval, and we're told you to approve it. But before we begin, I want to go over it with you. You would be entering a plea to the offense of assault, family violence, and misdemeanor. You would plead for 11 days at the Van Zandt County Jail with credit for the 11 days that you've already served, and you would pay a $4,000 fine. Is that correct? Yes, sir. As a result of that, this would preclude you from on. You understand? Yes, sir. You currently are looking at a jailer at around the time of the setting form that fund. It also means if you plead to this, that there would not be a possibility of your record being cleared, because you can't get a instruction or motion for non-disclosure on an assault family violence. You understand that? Yes, sir. So how do you now? Well, whatever you got, still going to go to the record. You understand? Yes, sir. You understand that a plea on this is going to include you from ever going playing to sport shooting, having firearms, and if you choose to ignore that part of the law, you can be prosecuted in the state or federal court or both. Yes, sir. You understand? Yes, sir. So we've gone over that well before coming to court today. You're going to ask the court to approve and assess that punishment in this case. Yes, sir. And you know what you're doing. Right. Yes, sir. This is a speak now for a little bit. Right. We're ready, right?
All right. Mr. Key, are you a United States citizen?
Yes, sir.
You do read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
There you are.
And you are pleased with Mr. Files as your attorney in this case?
Yes, sir.
Mr. Files, Mr. Harrison? And is there anything about this plea agreement today that you do not understand?
There you are.
Feel like you've had enough time to discuss the case with your attorneys and have all your questions answered?
Yes, sir.
Mr. Files, you believe Mr. Key to be competent today?
I do, Your Honor.
All right, Mr. Key, you're charged by information with a Class A misdemeanor offense of assault causes bodily injury to a family member that carries a range of punishment of confinement in the county jail for a period not to exceed 365 days or a fine to exceed $4,000. Do you understand that full range of punishment?
Yes, sir.
Understanding the range of punishment then, Mr. Key, how do you plead to assault causes bodily injury of a family member?
Guilty, Your Honor.
Are you pleading guilty because you are guilty of that offense?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
Court accepts the defendant's plea of guilt. Mr. Files, any objection to states one?
No objection to the exhibits marked and offered.
States one's admitted into evidence and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, I think that we are in compliance with victim notification. We have no written documentation from the victim. However, she has been to our office and she does not wish to be involved in the process.
Has she indicated whether she's supportive of the plea or unsupportive of the plea of the disposition?
Your Honor, all the information that I have, this is first case, all the information I have is that she indicated to us she wanted no part of the process.
She had, my understanding, she had no, she did not care what the disposition was.
Okay, thank you, Mr. Woodwhite. Anything further from the defense?
No, Your Honor. Mr. Key did ask me to apologize for being late, being attendance on. He had a traffic issue that simply not allocated time, did not anticipate that.
Thank you, Mr. Files. Thank you, Mr. Key. All right, the court's reviewed the submitted evidence in the case, finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the recommendation of the state. In the plea agreement, court hereby convicts Devin Scott Key of assault causes bodily injury of a family member. Court assesses his punishment at 11 days confinement in the county jail. Issues credit for 11 days for time served on this case. Court assesses a $4,000 fine. Court orders the fine to be paid today. Court also orders reimbursement fees of $15 and court costs of $270. Yes, and let me ask, on the plea agreement, it's written in 1 day in the Van Zandt County Jail with credit.
Before we realized we had 11 days before we can do it, and change and make that 11 and 1.
Okay.
It's great. To solve this case somewhat late, my client indicated that he would be able to pay it today. He needs to go to the bank to cash his check. So he can have it for me, right before 5 o'clock this afternoon.
Yeah, as long as it's paid today, that's what the judgment says. So. Mr. Woodlike or Ms. Heisel, I need one of you to sign the state certificate of discovery.
We had no issue with discovery. The family provided that the opportunity to go over.
That's it, yeah. I think everything else is good. All right, court's also signing the all right, Mr. Key, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted by the deputy.
I assume the intent of the court is to remain the sheriff with the understanding he's permitted to leave, he'll get the cashier's check.
He's gonna get fingerprinted right here and then he's free to go. So I just remain him to be fingerprinted and then with a time served, he's free to go. And I would suggest just getting a copy of the judgment so that when he shows back up at the clerk's office, he can tender his money without them having to look up his name and number. And if you want to, you can speak with Miss Officer Matura and she can get you a copy of that.
We should do that. Then there's the issue of Mr. Tapper. I understand that he did not do well.
I have not had that reported to me, so
The probation officer reported that he had admitted use of marijuana. No other.
if you will find Mr. Waddell or Officer Matura, then we'll get them in here and then I can call that case, but they're not here. Mr. Manning, did your client make it back? Is he still at the bank? Okay. You anticipate he's coming back?
I'm not sure how to do it next. I'll check out.
Okay. All right. Mr. Tapper, if you'll come forward. This is cause number CR 20-00371. State versus Hunter Tapper. Mr. Waddell,
The defendant admitted to this is true. I only confirmed the results. There's nothing else in the system but what he.
okay, well, let's do this. Let's do this. I'm gonna swear both of you in, and Officer Mature, if you'll come around. We'll get the show on room. Mr. Waddell, if you'll raise your right hand. Do each of you swear that the testimony that you give the court will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Waddell? All right. All right, so the court had ordered the pretrial release department to conduct a urinalysis of Mr. Hunter Tapper due to indications that Mr. Tapper had not reported in May or June on his conditions of pretrial release. Was a urinalysis exam administered on Mr. Tapper?
Yes, sir. I administered your analysis test. I was positive for marijuana. He admitted to my coworker using marijuana.
And what did he say was the date that he used it?
June 20th.
Any further information for the court on the administration of the test?
Yes, sir.
Mr. Files, any questions of Officer Waddell or Officer Ventura
Not based on what they've just advised in court? No.
from the state?
No question.
Thank you both.
I did, yeah, one quick.
Yes.
Did we get a base level? No, that's not, you're not gonna need to do that on this.
No, sir.
Normally, I would want a base level so that we could tell in the future whether he was going down or whether he was maintaining or going up. So there wouldn't be a question, so if it's possible for him to go to the lab today and get a base, I think that would be appropriate.
Court's going to, have we reset his case yet?
No, we did not.
All right.
Yes, I think it was out.
All right, court's going to set Mr. Tapper for docket call on August 10th at the request of counsel. Court is also going to find Mr. Tapper's bail to be insufficient in this case due to violation of the conditions of pretrial release. Court's going to double the the bail posted in this case. And so now the bail will be $40,000.
We're calling the court's attention to our earlier announcement. This is the case where he's before the court on a drug case, but there are two other cases, one of the cases out there that has not reached the DA's office yet. So, Bob, I think it's guessed August 10th, since we already have it over there. There's a possibility or probability that the state is not going to be prepared to go forward.
So you want to set it out later?
I would think so, that way,
How about,
Pretrial supervision, and that would give Ms. Curry the opportunity to be able to make an intelligent offer. Renegotiation for us to respond to it.
how about September 14th or 16th?
September 14th, 16th. You bracketed my birthday, so one of them's about. I like the courtroom, and next time I will remember not to walk between the court and the defendant when I'm trying to get over the state's thing.
That's okay. They position themselves there for that reason, so.
Either day is,
Either day. Which one you prefer, 14th or 16th?
What's birthday is it?
Tuesday and Thursday.
Tuesday, Thursday. That's what I think Thursday is, usually have less at the end of the week.
All right, we'll set Mr. Tapper then for docket call on September 16th. So, Mr. Tapper, I need you to come forward. I'm going to take you into custody at this time for violation of your pretrial release.
I gave him signed the form on its way up.
You come on up.
He'll sign. Chris had a show through.
Just go ahead and have a seat over there and the officer will be right with you. You can just leave the white one right there and then the other one's yours or Mr. Tapper's.
All right, all the minutes I have for the board, may be excused.
Yes, sir. You give Brett the day off?
both Mr. Perez and Mr.
Mario Martinez, CR 21-178. Mr. Martinez, the court has reviewed your request for a court-appointed attorney, finds that you are indigent on this date, has appointed the Honorable Jonathan Manning to represent you. Mr. Manning, have you had an opportunity to review the indictment with your client?
You should be.
Go ahead.
Judge, I think this law correctly understand the charge against this time are going to have to be not guilty of request to be set for pretrial.
Court will set Mr. Martinez for pretrial. I can set into September if that gives you more time due to your appointment today, Mr. Manning.
Judge, I'm fine with the normal setting of the case. I believe we'll be able to reach a resolution in it.
All right, and remind me when you're coming back.
Judge, the only date I have on my calendar is July 29th. That's it. I don't believe I have August dates.
Okay.
I take that back. I may set on 12th, August 12th. That'd be fine with that.
All right, court sets Mr. Martinez for pretrial on August 12th at 9 a.m. Mr. Martinez, once you sign the notice of appearance and get the yellow copy, I need you to report to pretrial release for additional paperwork. Mr. Perez, Jose Perez, CR 2188. Mr. Perez, set for pretrial.
Yes, Judge. I spoke to the state about some pretrial issues. They're going to look at the issues I brought up. I was requesting to set up for another pretrial and take that August 8th.
All right, court will set Mr. Perez for an additional pretrial on August 12th at 9 a.m. Mr. Perez, once you sign the copy and get the yellow copy, you're free to go.
Judge, with the exception of Mr. Morgan, I believe that concludes our business. I emailed Mr. Morgan, not heard back yet. That's his location for plans.
Okay. All right, you're free to go.
Thank you, Judge.
I'll let you know what I decide on Mr. Morgan. You can lead him to water. I said you can lead him to water.
Can't make him drink.
Can't make him drink. Well, you can. It's just hard. It's just hard. Stacy Rash. This is cause number CR 21-155 and CR 21-186. Ms. Rash, you are charged by information with driving while intoxicated, a second offense. That is a Class A misdemeanor, carries a range of punishment, not more than 365 days in the county jail, and a fine not to exceed $4,000. You're also charged by indictment with possession of controlled substance in penalty group 1, greater than or equal to 4 grams, less than 4 grams, a third-degree felony. If convicted, carries a range of punishment not less than 2 years or more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. The court has reviewed your application for court-appointed attorney. Court finds that you do not meet the requirements under the law for court-appointed attorney. So what I can do for you, Ms. Rash, is I can reset the case to give you time to go and hire an attorney. Okay? So I'm going to give you till August 24th, so it's a little more than 30 days. And so you need to go and speak with as many criminal attorneys as you can and determine, ask them questions about what they charge, if they have payment plans, things of that nature, and then come back with an attorney. There's plenty that've been here in the courthouse today. There's plenty here in Canton and surrounding areas. Okay. So I'm going to fill out this form. I'm going to have you sign it. And I'm gonna have you that new date of August 24th at 9 a.m. All right, Ms. Rash, you're going to sign here on the X, and then we're going to give you a copy of that form, and then we'll see you back on the 24th. What's your name? Pen? Yeah. Jeremy Reeves. Mr. Reeves, this is cause number CR 21-154 and 187. You're charged with driving while intoxicated, a Class B misdemeanor. Carries a range of punishment of not more than 180 days or a $2,000 fine. You're also charged by indictment with a second-degree felony offense of assault on a peace officer or judge. Carries a range of punishment of not less than 2 years or more than 20 years confinement. Are you going to hire an attorney to represent you?
Yes, sir. I think it's, representation.
Okay, and do you know who you're going to hire?
Not yet. I've gotten some referrals from Mike Smith or somebody else. That's correct.
How long do you think it would take you to hire someone? So if I give you 30 days, you believe that you'll hire an attorney?
Yes, sir.
All right, Mr. Reeves, I'm going to have you come back on August 12th. All right, Mr. Reeves, I'm gonna have you sign here. You're gonna get the yellow copy. After that, I need you to report to the pretrial release department. I'm gonna order you on the conditions of pretrial release. Once you get the paperwork from them, then you'll be free to go. Do me a favor while you're sitting there. Will you pin him so she can see him? Mr. Simmons, can you see and hear me okay?
Yes, Your Honor, I do appreciate the accommodations.
Yes, sir. And sorry, I didn't know who you were appearing on. I saw you in the Zoom and I was trying to figure that out. So, Miss,
Tiffany,
yes, and Miss Tabraham, our coordinator, has indicated to me that you're standing in for
Miss
Miss
Barbary.
Barbary. Okay. All right. So I've
Yes,
already
Your Honor.
CR 2354 and Miss Rankin is present in the courtroom. I'm not sure if you can see her, but she is there and we are set for docket call. Okay, go ahead.
Your Honor, we've received discovery. I think we're still in the negotiation process and waiting on an offer from the prosecutors. I think we kind of briefly talked about it last time, but I didn't write down an offer. And we were asking to just kick it down the road to another docket call.
State, is there an offer? And if there is one, has it been communicated?
Yes, Your Honor, there's state trial letter with the offer included is on the discovery portal. So they should have that.
When did that get uploaded and how long have they had it?
Oh,
It's out of the portal, May 11th.
And what was the offer in the pretrial letter?
Your Honor, it's 6 years TBC and a 35 bond.
And is that the only offer or are there varying offers?
Judge, I believe that's the only offer at this time, but I've had no interaction with one or the other.
Did you hear that, Mr. Simmons?
I'm having a hard, I cannot hear that, Your Honor.
Ms. Heisel said that the offer is 6 years TDC and that was uploaded in, or that was put onto a pretrial letter that was uploaded to Discovery on May 11th.
Oh, I didn't realize that. Because I remember I got discovery, we picked it up, but it was all on discs. I didn't know there was something that had been uploaded.
Well, has Miss Barbary been the attorney on this case or have you?
Yes, yes. We didn't realize there was anything uploaded on it.
Yeah, all discovery, absent digital discovery is provided online by the DA's office.
Okay.
And so defense is, I mean, she's been indicted since November of last year. Y'all haven't reviewed any of the discovery online?
Not the online stuff, just the digital stuff. I picked it up on our first setting that was first set on a pretrial. I got it from the DA's office. I did not realize there was pretrial discovery uploaded and there was other items.
So you don't have any offense reports, you only have videos?
There's some offense reports and videos all downloaded on disk that we got.
All right, so he's requesting an additional docket call. Any objection from the state? This is the first setting for docket call. I show that two pretrial
Yes,
settings,
Your Honor.
May and June. And this is the first docket call, state.
No objection, and then if their office would just contact Ms. Abby tomorrow, and set up the portal if they're not already.
Did you hear that, Mr. Simmons?
No, Your Honor.
All right, so you need to be in contact with the Van Zandt County DA's office, ask for Miss Stephanie Abney, and she can get you hooked up to the online portal so you can access all online discovery that the state provides.
I appreciate that. Thank you very much.
And so I'm going to reset Ms. Rankin for docket call on August 12th. Do you have any conflicts that day?
Let me double check, Your Honor, just real quick. No, Your Honor, that's a good time date for us.
Give me a notice form for, I ran out over here. All right, I'm gonna have your client sign a notice of appearance and reset her to August 12th and then let her go.
That's at 9 a.m., Your Honor.
That'll be at 9 a.m., yes.
Thank you.
You're welcome, and you're free to go. I'm gonna have her sign this and fill it out, and then I'm gonna let her go.
Thank you very much. I do appreciate accommodations, Your Honor, being in 2 different counties and Cynthia out sick today. I do
Absolutely.
appreciate it very much.
Yeah, you're very welcome.
Thank you.
You know, we should probably update this form to include higher counsel. Do that a lot. We should have its own box. All right, Ms. Rankin, I'm gonna have you sign here on this X where it says defendant, and then we're gonna give you a yellow copy, and then you'll be free to go. And we'll see you back on the 24th. Eighteen two nine three and CR 18294 State versus Ann Payne Alvestad. Ms. Alvestad, you are on community supervision out of this court for evading arrest or detention with a vehicle and also abandoning or endangering a child with criminal negligence. I see here that as a part of the sanctions court program, you've been brought to the court today because you admitted to consuming alcohol on June 21st of 2021. Also show that your interlock device was released early. So I've got concerns that I'm probably gonna, I'll tell you what, I'm just gonna order that your interlock be reinstalled on your vehicle. Okay. So as part of the sanctions court program, the recommended sanction for your consumption of alcohol is for you to serve 3 days in the county jail, for you to be amended for individual counseling at the Hope Road Counseling Center in Longview. That's the sanction that you can accept, or you can reject that, and we can submit your case to the DA's office, and they could file a motion to revoke your community supervision. What would you prefer to do? Do you understand you can't drink alcohol at all while you're on probation? That's going to end you up. I see that you're on deferred adjudication for a 3rd-degree felony. That means that you have a potential 10-year prison sentence hanging over your head for the evading arrest or detention of the vehicle. Do you have kids? Married? You have parents? You have a job? Well, you can't be a stay-at-home mom when you're in prison. So the decisions that you're making with regards to alcohol and any other thing that you're doing, those are decisions that you're making for your kids. Do you feed your kids? Why do you feed them? Why do you feed your kids? So they'll live, because you love them and you want them to be nourished, right? And taken care of. Why do you feed yourself? Same reason. Those are decisions that you make because you love someone and you want to see them do well. When you make a decision to drink, that's the same kind of decision. You got to make that decision determining, do you want yourself to be in the lives of your children or out of the lives of your children? So I'm going to approve the sanction, and I'm going to order you to serve 3 days in the county jail, beginning this Friday at 6 p.m. and with you being released on Sunday, July 18th at 6 a.m. And I hope that this is a wake-up call. You know, the purpose of sanctions court is to try to keep you from getting revoked and sent to prison. But we can only do so much. And you don't get time after time and chance after chance. You could have just been brought back in here and revoked and sentenced anywhere between 2 years and 10 years. And in addition to that, you have a state jail felony where you could be sent to prison for up to 2 years. And that's day for day. There's no parole on that. How old are your kids? 7, 9, and 10. Have you stopped to think about what kind of impact that would have on their lives at that age if you disappeared for 5, 7, 8, 9, 10 years of their life? You realize that you could go to jail and come out and your oldest be an adult? You would have missed that. All the teenage years, high school graduations, proms, dances, precious time. That's something you can't get back. So as you're sitting in jail on Friday, I want you to be thinking about this weekend that you're missing with the kids. And then I want you to multiply that by 10 years and then decide if alcohol is worth it. Okay? All right, I'm gonna have you report over here to the probation department. I've signed your amendments to the conditions. And let's let this be the last time that you come in here, okay? You can do it if you want to do it. All right, come forward and meet with Officer Ventura. see if Mr. Wandell's available. CR 21-185, Mitchell Ragland. Where have you been? We sent out a notice to,
In the process of, probably, I'm gonna spoil the house of the breakout, but different people checking my mail and I can stress it them. Make sure it's not put on spot. I have to follow.
does your bondman not keep you informed? Did you not check in with your bondsman?
He called me yesterday, tried to leave a voicemail, I believe my voicemail. I spoke with him briefly this morning.
You're charged by indictment with an aggravated assault causing serious bodily injury. It's a second-degree felony. If convicted, you could be sentenced to prison between 2 years and up to 20 years and a $10,000 fine. This is a very serious charge, one that you should take very serious and make sure that you know where you're supposed to be and when you're supposed to be there, because it affects your life and your liberty. Are you going to hire an attorney to represent you?
Yes, I'll be going to Dallas, I'll make court Tuesday, and my financial situation.
All right, this is what we're gonna do, Mr. Ragland. I'm gonna order you to a urinalysis test with Mr. Officer Waddell here. I want you to go and do that, and then come back and have a seat out here, and then Officer Waddell will tell me how you do. Okay? This way, right there, so I get shot. All right, we are back on the record. This is CR 21-185. All right, Mr. Ragland, are you gonna hire an attorney to represent you? You said yes, correct? And you said that, or you indicated to Officer Waddell that you're thinking about hiring Mr. Nolan White to represent you?
Yes, I spoke.
All right, this is what we're gonna do. I'm gonna let you go home today. All right, I see here that the urinalysis comes back, that you're positive for alcohol and marijuana. That's not gonna go away. We're gonna talk about that at your next court date. And you may go back to jail on that next court date. We're gonna see. I'm gonna think about it. In the meantime, I'm gonna reset you to come back on August 12th. I expect you to have your attorney with you. And after you leave today, I'm gonna order you to, you can even notice this up. I'm gonna order you to go out and see your bondsman today. Okay? Alcohol and marijuana is gonna end you back up in jail. I see that you paid your bondsman, or you posted bond of $150,000. That can get higher. I know it may not seem like it to you, but it can get higher if that's what you want me to do.
No, sir. I'll correct my actions.
I'm kind of astounded that I should even be having this conversation with you. If you want me to be 100% honest.
I am too.
Mr. Waddell's told me that he's been telling you the straight and narrow. And so I'm sure he's sitting over there thinking that you just don't care about what he's got to say. Maybe you don't care what I have to say.
No, sir, I do, Mr. Wardell. It's been more than helpful to me. I appreciate it.
So this is what I expect. I want you to go ahead and take that and sign right there on that X where it says defendant. And give it back to me. So between now and August 12th, I expect Mr. Waddell to have better information about you to tell me. I expect you to come back with Mr. White, and hopefully Mr. White and Mr. Waddell can convince me on August 12th that your bond should be found insufficient and you shouldn't go back to jail. Okay, so you've got about a little less than 30 days to change my mind. And those are the two guys that are going to be able to help convince me. You understand?
Yes, sir.
All right. We'll see you back on the 12th of August at 9 a.m. sharp.
Yeah, I think I'm making this good question.
Is it about your case? No, no. This is very serious. This is felony charge. This is not a traffic ticket. It's not one of these things where you come in and meet with the judge and tell him your side and the judge tells you what to do. I can't give you legal advice. The best thing you can do is go see Clay Nicholas and then go see and retain Mr. White or another licensed attorney as soon as you can, and then tell them that
Can
information.
you tell me if the district attorney's office to talk to me without, that's what it's like?
I'll tell you what, let's cross that bridge on the 12th. I think you're better off speaking to an attorney. This is a 2nd degree felony, 2 to 20. So this is not a misdemeanor where it's typical that you come in and waive your attorney and hear what they have to offer. You know, their offer may be somewhere between 2 and 20 years in prison. So you're better off hiring that. You're better off hiring that attorney.
Felt inclined over the last couple of months, expressed it to to Carl, of course, he's not a good advice. So I brought up
Yeah.
years.
Yeah, I'm prohibited by law from giving you legal advice, but the factual advice is an attorney is always in your best interest. So go and hire someone that's going to protect your rights, give them that information and let them determine what to do with it. All right, free to go. All right, we're gonna need someone to call Michael Scott Williams' name 3 times in the courthouse. Michael Scott Williams. Christopher John Morgan. All right, that's going to conclude this morning's docket. We will resume at 1:30 at the jail. Court will stream online.